are. We'll deal with that when we come to that point. And if you don't feel comfortable being in a room with a bunch of people, we will also have the option for you to be here just like this on a webinar. So look forward to that. We're really excited. I'm excited to meet people. So starting here and not being able to meet my members has not been a great or ideal situation. But
I agree. Yeah.
Really looking forward to meeting as so, and I know Sandy's itching to get out and see who our members are and non-members, but it's not about us. Today is about our speakers, and I want to go ahead and welcome them and thank them for being here today. And you know what? I'm just going to go based on who I see first, and I'd like you to please tell us a little bit about yourself and how long you've been doing this type of work and who you are. So we'll start out with my board member, Brian Rosales. Brian.
Thanks, Robert. So good afternoon, everybody. Some of you may know me. I've been practicing landlord-tenant law for over 20 years. Harris, Rosales, and Harris we've been together now just about right at 20 years this month. We've been in Alameda County the whole time. We go all over the place in Northern California, essentially, but we're based in Alameda County. Our office is in Alameda County, and I've been a participant with RHA for most of those years. I've taught classes over the years, and so I've really come to appreciate the role that RHA does. We are a litigation firm. We do a lot of evictions. We do also fair housing defense and a lot of broader landlord-tenant type stuff. But the topic of the day, of course, is rent and that sort of stuff. And that tends to be the bulk of our cases. And so therefore, the bulk of my experience has been in non-payment of rent situations. And of course, I've had to have a crash course on the current law and what does and does not apply, which is certainly what everybody's concern is. So I'm happy to be here, and hopefully I'm able to answer some of your questions and maybe help a little bit today.
Awesome. Thank you, Brian. And next up, I'd like to ask Emily to give a little background. And I just met Emily very recent, so excited to have you here on our panel today, Emily.
Thank you. My name is Emily Hislop. I'm with Project Sentinel. We're a nonprofit housing services agency. I'm in the tenant landlord counseling, mediation, neutral services division, along with my colleague, Mark Thomasee. Our services in Alameda County are pretty limited. Mark Thomasee is the case manager for tenant landlord counseling. Well, he'll introduce himself for Fremont, and we do support Hayward in their administration of their rent stabilization program, and are also doing temporary rent mediations around COVID-19 rental debt. I've been with the agency for 5 years to administer some rent stabilization programs to support some cities in that, and I also help educate staff. I've been keeping up to date on all the moratoriums and changing laws and the Tenant Protection Act. Prior to this, I was an attorney, but I did enjoy more being a neutral and enjoy this role as educating people and sort of empowering them to understand their rights and obligations.
Awesome. Well, thank you, Emily, for being here today. Really excited to hear from you. And last but not least, Mark, who I just met. So Mark, let's hear from you.
So I'm Mark Thomasee. I've been with Project Sentinel for about 20 years, and I've been in Fremont, working in the city of Fremont since 2003. We have Project Sentinel has a contract with the city of Fremont to provide both fair housing and landlord-tenant counseling services. And then more recently, we took over the position of designated service provider for the city's rent review program, which was amended and updated in 2018. For the first year and a half, the city managed that program directly with their city staff, and then beginning of last year, we took over as the service provider for the rent review program. So that's probably enough. Basically, we help both tenants and landlords. As Emily said, we're neutral. All of our services are confidential, they're free. You can contact us by phone, by email. Prior to COVID, you could come into our office located at the Family Resource Center across from Fremont City Hall. So I think I'm seeing a lot of activity in the building recently, and I think we're getting a little bit closer to opening up to in-person visits from the public. So, well, we're looking forward to that. So back to you, Robert.
Awesome. Well, thank you, Mark. And we definitely are looking forward to opening up. I'll tell you that. So I totally agree with you there. So, all right. Well, hey, let's just dive right into it. And so I have some questions that I want to ask our speakers. And so this is why you're here, attendees. So here we go. So, talk to me a little bit about, and whoever wants to take on this question first, the Alameda County Rental Relief Program, but probably not only just that. Let's talk about Fremont and Alameda County. As most of you know on the call, Fremont and Oakland got money directly because their cities are 200,000 people or more. So they were able to get direct funding. And the rest of us in Alameda County, that program is being run by the county itself. We are one of those that is helping to educate, such as today, and get the word out to our members and non-members alike in our community. But speakers, Brian, Emily, and Mark, talk to me about the differences and what you're seeing in the rental relief program.
Well, I can talk a little bit about Fremont. The Fremont program, which they've called Keep Fremont Housed, went live on April 1st, and I heard this week that they've up to now they've received about 900 applications. They're processing them as quickly as they can. They've already gotten out checks to some landlords, have been funded. One of the landlords that I've counseled several times told me about a week ago that he had just received his check for $27,000. So he was pretty pleased with that. The nice thing about the Fremont program is that they do pay 100% of unpaid rent, back rent, as long as the tenant's eligible, as long as their income is below 80% of median income. They've been impacted by COVID. They're still in the unit. So there isn't that 80% if they forgive 20% situation, although, maybe Emily can talk about, I saw in the news recently that the state program is planning to go up to 100%. I don't know if we know when that's going to happen, but okay, there we
I'm
go.
just putting a slide up to help to support you.
Okay.
So you know what the 80% threshold is for everyone.
Right. So they do, in the Fremont program, they do give a priority to people whose income is below 50% of median income, or if they've been unemployed for 90 days or more. There's a few other priorities. Tenants in below market rate complexes have a certain priority. So they'll be funded first, but it looks like just about everybody, probably everybody who's eligible is going to be funded. The city has access to altogether, I believe it's over $15 million in Fremont. So I don't think there's any chance they're going to run out anytime real soon.
And I could, I just want to jump in here because I saw that 30% AMI on your slide, Emily. To speak a little bit about Alameda County, that's what the threshold is right now. Now, that's only phase 1 of the program. So phase 2 will bring in everybody else. But as I've encouraged our members and non-members alike, apply for the program, get your paperwork in, don't delay, don't wait. And as you saw in chat, Emily put a link there for you. And I also put a link to our website. You could go to the RHA website and it links you directly to the county program. So those are 2 resources that you could utilize at this point. So, and Mark and Emily, I'm sorry, didn't mean to interrupt, but go on.
No problem. One thing I want to mention about the Fremont program, which Emily put on the slide, is that the tenant, unlike the state program, the tenant is the one that has to initiate the application. Landlords cannot cannot submit an application for the tenant or for themselves. The tenant has to start the application. And then of course the landlord has certain documents and information that they have to submit as well. So just wanted to mention that.
Awesome. Great. Okay. Is there anything else that you wanted to cover, Emily, regarding the rent relief program at this point?
I'll just note there was a change in Oakland, and right now it's only through the state program. And I do have a slide, and these slides are in a PDF that Robert will hopefully send out, so the links will work. So anywhere else in Alameda County, as you all have discussed, is through this achousingsecure.org. And from what I understand, both the landlord or the tenant can initiate the application process there.
Awesome. Awesome. Talk to me about the application process. Obviously, everyone on the call, you saw the 2 links that we put into chat, so please feel free to access those. But let's talk a little bit about what's the process, because we hear from our members and non-members, oh, well, Robert, I submitted and I heard back, but when do I get my money? And I know I can tell you, rest assured, I'm hearing from some of our members that they are starting to get payouts, that process is happening. And many of them, as many of you know, Alameda County started their program March 17th. Was a soft launch. I think they're a little bit more on it now and catching up. But Emily and Mark, what can you tell our members about the application process? Or if they have questions, where can they go and who can they reach out to?
Well, in Fremont, if there's any problems, there is a phone number, 510-574-2028 is a number that tenants or landlords can call if they have questions about the process, they're running into problems. They do have staff available. Some tenants they don't have the computer ability to documents onto the online website, and so there are people here at the FRC. They can meet with them actually at the FRC here and assist them with uploading documents. So no one should have any trouble in being able to apply as long as they're eligible.
Great. Okay. Emily, I see that number and I recognize the number in your chat or on your slides. Do you want to talk a little bit about that?
So my general experience is with the state program, so I can't really speak to how the rollout of the county program is in Alameda County. I do know they partnered with 211, so you can call 211 from any phone to get information or how you can get help applying. And also visit the website, I imagine.
Perfect. Yes, you're absolutely right on that, Emily, because as soon as I saw that 211, I'm like, that number looks familiar. So, and I know that's a great resource, again, for our members. If you do have a question, you need help or assistance with applying, again, in the Alameda County program, dial that 211. It's a great start. And you can also always contact your RHA office, where we'll help you and guide you as much as we can. So awesome. So I think we can probably move on, and I see questions are coming through. So and Mark, there was one. Could you put that phone number in chat so then people can grab that from you also? That would be awesome.
Okay.
Cool. So we're going to go ahead and move on to talk more now about, unless Emily, was there any more that you wanted to talk about in the rent relief program, or Mark?
No, I just put that slide up so people would have the info handy.
Awesome. And again, as Emily mentioned, everyone on the call, we will send the slides and we will send a video of today's webinar to all our registered attendees. So, okay, well, let's go on to the eviction process, because I know that there's a lot of questions around eviction and what's going on with the moratorium, and, when can I start, taking our people to court? And I always caution our members or any other calls that we get in, hey, the eviction moratorium right now is to June 31st. the courts are going to be swamped, but I'm not an attorney. However, we do have our attorney on here who is on our board, Brian Rosales. So Brian, maybe you can jump in at this point and kind of talk about the eviction moratorium and what you're seeing, and what advice could you give our members today?
Sure. Yeah, I know that everybody's wanting to get back to normal. I guess the one thing to take away from this today is that we're not going to get back to normal anytime soon. One of the things is that the Alameda County moratorium, that is what really controls Alameda County. The state laws, the 3088 that was passed in September, then extended by SB 91 in January, really doesn't have an effect on you as an Alameda County landlord, except for the rental assistance aspect of it, that which was enacted in SB 91. That, of course, is part of what we're talking about today, the main thrust of it. That is available to you and you can apply for it. But as far as the Alameda County moratorium, its duration is open-ended. So it's not tied to the state law. The state law right now, the Tenant Act, is set to expire on June 30th. However, the Alameda County ordinance is tied to the local state of emergency, which is still in effect. And it will expire 60, in theory, the state program or the state law could end as currently scheduled, and the Alameda County could continue its state of emergency into the future. Could that be months, years? Who knows? I doubt it'll be years, but it could be months. Also, it's possible that the Board of Supervisors may decide to end it on their own, just vote and say, okay, it's done. So we really don't know when it's going to end, but right now it's in effect. And what that effect means is that you really cannot terminate a tenancy in Alameda County except for very limited reasons. One is if it's an Ellis Act, you're going to remove the property from the rental market. Another is if there's a court order or a city order that's requiring you to end the tenancy, perhaps some sort of code violations or something, eminent domain perhaps, which is very rare. And then the other reason is a health or safety issue, that continuing the tenancy creates a health and safety threat to the public at large or other tenants or something like that. Those types of evictions are not that common. And also they're subject to the court's review. The judge in Alameda County that handles UDs or is the presiding judge for UDs, he reviews those cases. In other words, you would serve a notice for some bad behavior, say a tenant's attacking other tenant or something like that, and then you would submit it to the court for approval to go forward. The judge will review it and decide whether or not it meets that criteria for health or safety, and then and only then allow you to move forward. So as you can imagine, over the course of the last maybe 10 months or so, it's been very, very high standard whether or not he'll allow it to go forward. But some cases have gone forward, but those are the exception. It doesn't help the landlord who has authorized pet issues or something like that. It has kind of handcuffed you as far as enforcing your rules and stuff like that. That's going to continue while this more place. Also, a brief explanation. A lot of people will ask, well, the state passed this law. Why doesn't it apply in Alameda County? The state law itself said that any local ordinance that was in effect as of August 19th of last year remains in effect. And this Alameda moratorium was in effect before then. So that's why it still applies, and it's limited your ability to really do anything in regards to doing any type of eviction. Certainly non-payment of rent is not a health or safety issue, and so you can't pursue anything in that regard. Also, one thing to keep in mind, the repayment period in the state laws gives the tenant until the 30th of June to pay 25% if they submit a declaration and follow that procedures. You're not serving notice notices in Alameda County because you can't terminate tenancy. So you're not provoking, so to speak, those declarations. Plus, once the moratorium is lifted, the tenant does have 12 months from when the rent was due, whenever that rent was due, to pay it back. So if you have a tenant in Alameda County who didn't pay this month's rent, let's say May's rent, their obligation to pay it back is 12 months from May. So that goes into next year. So your timeframes are going to be staggered on that. Plus, under the Alameda County ordinance, there is no obligation to pay 25%. Under the ordinance, 100% of the rent that became due during the moratorium is consumer debt. So you are going to be left to small claims as your only remedy to seek that back amounts. And also, and this is very important, you cannot retaliate against a tenant who happens to owe that what we call COVID debt. You cannot choose to not renew the tenancy, or in any other action to enforce your contract. They can raise that as a defense. In other words, saying that the reason why you're terminating the tenancy is not the true reason, it's really because of the back rent. So that's going to hang over your tenancy, so to speak, for quite some time. But that's all the Alameda County ordinance that's controlling that, and that's what applies to you. So in a larger sense, the fact that we had AB 3088 and SB 91 enacted doesn't matter to you, to put it bluntly. The Alameda County ordinance is what's controlling how you're managing your properties day to day.
So Brian, I want to bring in Emily and Mark here, being that some of our members and non-members that are on the call, they might have properties in other jurisdictions or counties outside of Alameda County. What are, Emily and Mark, what are you guys seeing that you could bring into this conversation that's larger than just Alameda County?
Well, Robert, I'd like to stay in Fremont for a moment before we go outside of Alameda County.
Okay. Perfect.
Brian, I've talked to a number of landlords and tenants where the landlord has issued termination notices to the tenant in order to, and the stated reason on the notice is to sell the property because the landlord has decided for whatever reason they want to sell the property. So have you seen any cases like that go through the eviction process, and have they been successful at all? Can you address that?
Seen, and I do have attorneys that kind of communicate back and forth, and we'll share instances like that. I've not seen anybody file a suit for that reason, and in fact, that's not a reason. That's not an exception under the Alameda County ordinance. Now, one would argue if it's a single family home, by definition, if I'm selling them, then am I taking it off the market? Well, not necessarily. You're selling it to another owner, and so and they could re-rent it, or they can continue with your own tenant. So that's not, in my opinion, a valid basis to terminate a tenancy in Alameda County. And if someone were to contact me saying they were contemplating that, I would advise them against it, mainly because the Alameda County ordinance says you cannot terminate a tenancy or otherwise cause a tenant to vacate. So let's say you issue that type of a notice and the tenant ends up vacating pursuant to that notice. In theory, you could be liable under the ordinance for violating it by making the tenant vacate when selling the property is not one of those exceptions. So it doesn't seem logical that would not be allowed, but under the reading of the ordinance that most attorneys agree with, selling the property is not a basis to terminate the tenancy while the ordinance is in effect.
Okay, so you just haven't seen or haven't heard of any cases based on that, for that reason, going through the courts?
I have not, no, only post foreclosure. If you purchase the property at a foreclosure and the occupant is the former owner, yes, the court has allowed that. But if it was a tenant in possession, probably would not have allowed it.
Yeah, I've heard of a couple of cases of where owners have been successful with evictions based on owner move-ins. That's another way that the property can be withdrawn from the rental market under that first exception in the county ordinance.
Right, and I think that would be an LSAC saying, look, it's a single family home. I'm not renting, I'm moving it in, but technically that would be be an LSAC. It's not an owner movement. Those are technically two different things. But yes, if you were going to use the LSAC because you're planning to not rent it anymore because you're going to live in it, that would be sufficient.
Yeah. Okay.
You know, I
Thank
want
you.
to kind of stay on this topic because we do get a lot of calls on this, and I want to hear from all three of you on this. You know, what are the three reasons right now that you can evict a tenant during this time of COVID? Because, you know, sometimes I get confused and it's very confusing, you know, county and state. So that's why I was also saying, Emily, I'd love to hear what the state perspective is. So, but what are those three reasons right now that someone could be evicted?
Okay, so and the three reasons we're talking about is Alameda County. The statewide just cause applies, which has
Correct.
a variety of things. But in Alameda County, it's three exceptions that, listen, I'm just going to read off the ordinance. It says, you know, one, a landlord is taking the residential unit off the residential rental market in accordance with the government code section 7060, which is the LSAC, okay? And it complies with all local ordinances. In other words, Hayward, Fremont, the city themselves may have additional ways to accomplish an LSAC eviction. So it's LSAC. Number two is the residential unit must be vacated to comply with an order issued by a government agency or court. So again, condemnation of some sort, something like that, that's very rare. But that's not you doing it. The government told you you have to vacate the unit. Then the other one, the third one, which I said is the only one that I've seen so far, is continued occupancy by the resident poses an imminent threat to health or safety. For the purpose of this ordinance, the basis of this exception cannot be the resident's COVID-19 illness or exposure to COVID-19 or the actual or suspected. So preemptively, you can tell they kind of cut off the landlord that would say, I have a tenant infected with COVID, they're going to get everybody else infected, I have to terminate the tenancy. That would kind of go against the whole purpose of the ordinance, which is to keep people housed. But those are the three reasons. That's it. So selling the property, as you can tell, is not listed in there. So that therefore, by definition, it's not good cause. This is an exclusive list. It's not listed. It's not a reason.
So that's Alameda County. So now what does the state say on that, Emily?
Well, yeah.
Oh, go ahead, Emily.
Okay. So what the state did was apply the just cause of eviction protections that were in AB 1482 to all tenancies with some further limitations. I will point out that in the state law, it does have a carve out that the property, if the property is being put up for sale, if the buyer intends to occupy the property and the sale is in contract, that's an allowable termination. However, they also have withdrawal of the unit from the rental market. So it's a little, that takes some legal interpretation, which, you know, you could argue either way, but since there's that carve out about, you can't just, you know, sell the property, it's got to be in contract with the buyer who intends to live there, and that the spirit of the law is to keep people housed. I know that the withdrawal from the rental market has caused some consternation. I don't know where the courts have ended up on that, but there are also tenant fault issues can be the basis, but that's a two-step noticing process. So that still has to be followed. You have to give the tenant opportunity to cure, but there's probably more gray areas. And yeah, we try to help people work things out and figure out a resolution. We're not trying to drive anybody into court. We're trying to relieve the courts of that burden, but
right.
Also to know that there are retaliation provisions, increased penalties. So if anything's seen as a retaliation for non-payment of rent, you know, a landlord has that exposure to that type of liability as well.
Awesome. Brian, what were you going to say?
No, I just saying that, yeah, the AB 1482, which is the statewide just cause enacted last year, it does apply across the board according to the state, but the localities are given the discretion to narrow it if they wish. An example would be Contra Costa. In that county, as Emily kind of mentioned, there's a fault where they've breached the agreement, and there's also no fault cause under 1482. Contra Costa has narrowed that the no fault is not allowed. For example, if you're wanting to rehab the property or something like that, a lot of those are not allowed. So they've limited it to owner move-in and as a basis. So while the statewide is kind of the template, you still would need to look at your local localities to see if they've narrowed that even further. And one example is of the city of Richmond itself in March basically they adopted for fault Alameda County's ordinance, basically, in that in Richmond, it is only health or safety, LSAC, or city order. So statewide in general, it's the 1482, but the localities can still narrow that as far as the just cause.
And
so
just to address the question in the chat and to clarify, what happened with the AB 3088 and SB 91 is that the just cause protections that were laid out in AB 1482 are temporarily applied to all tenancies across the board. So there's no exemption. So I think that
I've had people yelling at me, but it's a single family home. I said, no, for the purposes of this act, it's across the board for now. Yeah.
So since you brought up locality, Mark, what do you see in Fremont?
I'm sorry, as far as what?
As far as this whole conversation and evictions, I mean, I know you're in Alameda County, but anything that you're seeing different going on in Fremont? Or
no, as I mentioned, a lot of frustrated landlords wanting to sell their property to get the tenants out in order to sell the property. None of them have been successful, so that's why I wanted to confirm that with Brian. But as I said, I have heard of a couple of cases that were successful through the courts through unlawful detainers for owner move-ins. Those have been successful in a couple of cases, not a lot. But generally, landlords they're stuck right now, as long as this moratorium is still in effect. So what I'm hearing is a lot of constant emails or calls from landlords wanting to know, when's this thing going to end? And like Brian said, we don't know. I know the governor was talking about maybe lifting restrictions around June 15th. I said, if that happened, then we'd be looking at the middle of August, maybe the end of August, before the county ordinance expires. So again, we don't know. But that's the main concern that I'm hearing from landlords in Fremont is, when's this thing going to end?
Yeah, and I was just going to ask you if you can all look into your individual crystal balls, because I think a lot of people on the call are probably wondering that. I mean, what are you all seeing trend or what what do you believe, the three of you, and I know it's a total guess right now because everything's so fluid and changes daily. I think that's something we learned with COVID. We have to be ready to pivot and change. I love those two words. But what are the three of you seeing as far as trends and what could be changing here soon in the future?
I'm just going to do a pitch for why landlords should try their best to apply for these rent relief funds, and there's more coming on the way.
Awesome.
Because I think the biggest in what I've seen in the last year and a half is if the money doesn't start flowing, there's going to be a reason for extending moratoriums, either on the local or state level. So the money's there. It just needs to be accessed and start flowing to landlords. And the whole point of these funds is to keep people housed. So the tenants, and the purpose is to continue their housing. So we just urge everyone to use their best efforts to access these funds. And if you have any questions or concerns, read about it on the website, or, I can give you a whole pitch for why you don't want to try to collect that debt in court, because even if you're only getting 80%, that's the best deal you could probably ever get than trying to pursue it legally.
Emily, you brought up actually a question that's come up also a lot from members and non-members. We saw the governor's statement. He's going to move it to 100% financing now statewide, which is a good thing. Well, what we're hoping. But you brought up a good point. So this money's there, and in the original relief program layout, it said, it would cover rent till March 31st of this year. Do you all see that that's going to be extended probably for the end of the year? So if there's a property owner on the line right now who's concerned that their tenant isn't going to be paying for the rest of this year, can you kind of maybe calm that and squash that down a little bit?
I'll let Brian or Mark talk, but the funding that's going on now is based on federal funds that were passed at the end of last year, which is a totally different administration and had different Treasury guidance of how those funds could be spent. The new set of funds from the American Rescue, whatever plan act, I don't know, has a different set of guidelines, and that's what's being worked on right now. We don't know, and that's part of what the governor announced.
Okay.
And I think everybody's intent is to, keep people housed and, spend the money as appropriately as possible. But I can let others give insight.
Emily, I have a quick question, if you don't mind me jumping in here, because I do have a lot of people kind of asking too, and you may have touched on this before. I'm sorry, I was kind of keeping track of attendance. But if the landlord's going to go and do their due diligence on trying to get that money, and what if the tenant just doesn't want to have any part of it? If they're having trouble getting them to agree to do their part of it, how is that working? What does that mean to the landlord?
I would encourage the landlord to try to have the tenant, connect with either Central Legal or another partner that can, explain the benefits, engage a third party neutral to help even out both sides, because sometimes it just takes hearing it from somebody else to get both sides on board.
Perfect. Thank you.
So Brian and Mark, did you have anything to throw in?
Yeah, I think I've seen a couple of questions. This kind of follows up with Sandy's question, is that what if the tenant doesn't apply, doesn't cooperate? And the law, when they enacted it, it's clearly had in mind the belief that tenants would jump at this and do what they could to get these things paid. It's a pretty good deal for the tenant. They get out from underneath debt, the landlord gets their money, everybody's happy. But I do have clients who are a little frustrated, to say the least, that some tenants are just not responding or flat out telling them, I don't want to be bothered, etc. The law does not have any requirement whatsoever that the tenant participate, nor the landlord. It does not require it. It is voluntary. So if you have a tenant that does not reach out and does not help get assistance, that is their right, in a sense. They don't have to participate, and they would default to, and again, this is where it's problematic in Alameda County, you would be able to typically serve that tenant a 15-day notice and get a declaration of hardship, triggering their responsibility to pay 25% by June 30th. Alameda County, you're kind of limited, really can't do that. Plus, Alameda County turns everything into COVID debt, and so therefore, in Alameda County, strong argument, they don't have to pay 25% by June 30th and can ignore any attempts to get assistance. Now, kind of going back to the crystal ball, is this thing going to go beyond June 30th? I think it may. Again, the whole point of this is twofold, is to keep people housed, get landlords some money, and get tenants back to a position where they can pay rent going forward. That last part seems to be a major concern, in that the economy is not fully open yet, and there's going to be, in theory, plenty of tenants who still don't have the wherewithal to pay rent beginning July 1. That may or may not be the case, but that, I think, is an impetus. My sense is we may get a little bit of an extension. Total guess on my part, I know that there are Assemblyman Chu, who was really pushing this to begin with, wanted to get to the end of December back in January, and he got to June. I say he, I'm using him as a figurehead for that side. They may do it. We don't know. And the problem is they're probably going to act towards the end of June. So we won't know until the end of June whether there's going to be an extension. But your tenants don't have an obligation to apply and do all those things. There is no requirement that they show that they've been harmed. I saw one question. What if they've been working this whole time? They've been buying new cars. I know for a fact that they haven't been affected. That is irrelevant. They don't have an obligation to prove that they've been affected. Certainly under the state law, all that's required is a declaration, and that's it. So while it may be frustrating or annoying and all those things, the law doesn't require a tenant to actually show that they've been affected. So you're just going to have to take them at their word, despite any evidence to the contrary. That's kind of where that's at.
And Brian, this may be different for Alameda County, but because I think the way it was written had to do with which option the locality chose. But to file a court action under the state law, the landlord has to to collect the debt. They have to document that they made attempts to apply for rent relief, or that they, showed cooperation. Otherwise, they might be precluded from being awarded the full debt.
Yeah, that's a very good point. In the SB 91, as part of this, the small claims availability, they did several things. One is they lifted the limit on it, so you can go above the $5,000 or $10,000 limit. But to your point, in those actions, landlord is required to indicate that they did make attempts to see if the tenant did qualify for assistance, and number two, actually tried to get the assistance. And if you are unable to do that or do not do that, the court has the ability to reduce your recovery. In theory, by 80% to 100%, I don't know. But so the landlord, if you're going to want to sue later on for that money, you need to show that you tried to get the assistance. Now, if you have a tenant that did not cooperate, that's fine, but you need to go jump through those hoops to make sure you tried, and then you would just simply need to tell the court and prove, hey, I did contact them, I did what I had to do, they wouldn't help me. But yeah, you cannot just sit there and just wait, so to speak. Okay, the gates are open now, and now I can sue for that rent now and go forward. You're going to need to show that you tried to recover those things through assistance.
Great. We're coming up at the 12:45 mark here, and I know I see there's several questions in chat. Before we get to those, from our panelists, are there any final thoughts that you want to leave with the audience, and then we'll get to our questions here?
I can just say patience.
Okay.
Longer than a year. We're just going to have to wait. It is unknown, and that's what's frustrated.
Yeah.
But you're attending this, which is a good thing. You just need to find out where you can apply and do it the best that you can to try to get assistance. But you have to accept the fact that really it's just out of your hands. You don't have any control over this, which is frustrating. So patience.
Emily?
I'll just note that the slides that you'll receive have a couple slides about small landlord mortgage relief options. Our Project Sentinel has a HUD housing counselor division, and the definition of what small landlord is. This is from AB 3088, but if you have one impacted tenant, you might have some mortgage relief options, either forbearance or repayment option, or like modification. So it's just something to consider if you do have buildings that are less than 4 units, I think.
Okay.
That is available, and our HUD housing counselors lived through the foreclosure crisis and everything. So they're very skilled at how to help people work with their lenders to work something out.
Mark?
No, I think they've covered it pretty well. Thank you.
Awesome.
Awesome.
Okay, so Sandy, you're great at keeping track of our questions. So why don't you start with the questions for our panelists?
Well, here's the thing, Robert, is it looks like throughout the conversation, many of them have been answered. The first one that came in was from V. Nguyen, and it was about, if your tenant refuses to apply, that they have submitted their portion, but they've been, they haven't yet had the tenant apply, but that was addressed by both Brian and Emily. And then the other questions that were coming, well, there's the one from Al. I think it's Al and Tracy and Heather. They all are kind of in the same situation where they have submitted their applications. They've emailed the program asking if they have received their application, and a month later their tenant had also submitted, but they still haven't they just, I guess they're just wondering if there's any phone number or a person that they could call or contact to find out what the status is of their application. So is this where they're calling the 211 number?
I can't speak directly to Alameda counties, but we're having the same issues and I would caution them to be a little patient. If both sides have submitted, just give a little time, because even if somebody answered the phone somewhere, they might not have anything to say. This is a huge lift.
Okay.
$2.5 billion is trying to be distributed through
That's
this program
helpful,
across
yeah.
the state. And what I've said to people is it's probably going to be like a slow moving like steam train coming out of the station. It's going to be slow at first, and then it'll pick up once the channels are open.
That's
so
good.
Patience.
Thank you.
So I can speak a little bit about.
That's the motto.
I can speak a little bit about what CAA talked about yesterday in their board meeting, and some other information that I have for our attendees. So according to CAA, there was only $1 million that has been distributed statewide.
It's a little higher.
Is it a little higher?
Yeah.
Oh, I'm sorry. What is that? I thought I heard.
I don't know the exact number. It was $1 million like a few weeks ago, but I think it's been more now.
Okay.
I only know bits and pieces what I hear from other meetings, but I think.
Okay, so perfect. Okay, so it is higher. I will say in Alameda County, from what I heard about a month ago, they had received 1,500 applications from landlords only. And they only have 3 entities that are going through those applications right now. And the number that I'm hearing is that they're getting to about 5 to 7 of them a week, checking through paperwork and double checking with the tenant side and et cetera, et cetera. So what I'm telling members is I highly encourage you, when you go and fill out the paperwork and you start that application, have all the pieces together, and it lays out for you step by step. You need your W-9, you need your lease, you need X, Y, and Z. The more you can provide at the beginning of the process, the quicker your application will move through the process. But as Emily said, keep in mind, there's $2.6 billion that we're trying to distribute.
Yeah.
And there's only 3 entities that are doing this specifically in Alameda County. It's going to take time. And I know it's frustrating. And I know your banks are not letting you, well, that's great for you, but you still have to pay your mortgage. Or Alameda County, that's great for you, but you still have to pay your property taxes. I get that part. And I think we can all agree on that. But it's going to take time. And once I know that the county is trying to bring in other entities to help alleviate some of that, but that's taking time too. So patience. That's
what I said. The motto of this recording is patience. There's just another couple of questions, but again, I think Ramona Chang was asking if the property owners must cooperate with the rental assistance program, and Brian very clearly stated that it's not. It's a volunteer thing. Tenants is the same. They don't have to cooperate. So he did address that. So thank you, Ramona. And then also, I think, Brian, you also answered Jasmine when she questioned, aren't affordable properties excluded from AB 1482?
Right. As Emily pointed out, it's across the board. Okay. So the normal exceptions don't apply while SB 91's in effect.
Okay. I think that was. I think you also answered, Brian, about the tenant who earns more than median or who refuses to apply and maybe gaming the system. You did. Yeah,
there's nothing you can do about that. You want to show that you did apply, you did what you could. Sounds like you have. And then if you have to sue that person down the road, you can show I did apply. I tried to find out if they were qualified, and I couldn't do any more.
Perfect. Yeah. Okay. Yeah, I think that's going to be it, Robert. Yeah.
Are there any other questions from our attendees that maybe weren't answered that you'd like to ask? I'm trying to see if anybody has their hand up or or I'm not seeing anybody, or if anybody else wants to put, okay, there's one more in chat. When submitting an application for relief, proof of COVID hardship is requested, so not necessarily needed. And that's from Jasmine. Can any of you speak to that
I think that's required.
question?
There has to be some kind of documentation, some kind of, whether it's a letter from an employer or
Oh,
bank statements, there's got to be some kind of documentation or even an affidavit of some kind explaining why they've been impacted by COVID. They had to stay home with their children. They couldn't work, whatever.
the state program, the declaration, which is signed under penalty of perjury, is sufficient.
Right, but in Fremont and probably Alameda County, there has to be some kind of documentation.
Okay.
So then there's another question from Al. Why do you need W-9 forms? So I will say this, and maybe the other speakers. Actually, let's hear the other speakers first. Do any of you know why a W-9 form is needed?
It is for the state program. It's your tax ID number because they're, what have a duty to prevent fraud.
Correct.
Yeah, it's a tax issue. They have to do it.
That's what I heard too. So, okay, perfect. All right. I think that's it. So, again, okay. So any other questions? If not, I'm going to give you back some of your time on Friday. Panelists, any further comments or pieces of advice? Or
I just wanted to clarify on the proof of COVID hardship. My point is, as far as the tenant not having to provide it, that's to you. If they're applying for relief, those applications generally require some sort, either a statement or some other proof, depending on the assistance program. But if a tenant chooses to not participate or just tell you I'm not paying my rent, they really don't have to, in Alameda County, provide you with any backup. But if they're going to apply for assistance, yeah, those programs will generally require something from them.
okay, great. Well, I want to go ahead and thank our speakers. What a wealth of information and knowledge. I want to thank all of our attendees for being online today. Again, continue to check out our Rental Housing Association Southern Alameda County website for any updates. Watch your email blasts that come out from our office too. We're pretty good at sending out any legislative information that's coming out or any updates to our programs or any other information we hear about COVID rental relief and evictions. Again, I want to thank Brian, Emily, and Mark. Really appreciated your time on this call.
Absolutely.
And all our attendees, we will follow up with the PDF that Emily sent us along with the recording of this program. So with that, thank you all. Have a great weekend. Happy Friday, and we will see you soon. All right. Take
Thank
care.
you.
Thank you, Robert.
All
Take
right.
care.
Thank you.